Judge Rogers, may I open court?
Please do.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 18-5356, Stephen Aguiar, Appellant versus Drug Enforcement Administration. Ms. Bassel for the appellant, Mr. Walker for the appellee.
Good morning.
Good morning, Judge Rogers. Thank you, and may it please the court. Stacey Fossil, court-appointed amicus in support of appellant. At issue in this case is Mr. Aguiar's request for GPS tracking data in the form that the DEA itself viewed that data during its investigation of Mr. Aguiar, and the form in which the DEA presented the data to the jury during Mr. Aguiar's trial, that is, plotted on a map. In response to Mr. Aguiar's request, the DEA provided Mr. Aguiar with 351 pages of longitude and latitude coordinates and has refused to provide Mr. Aguiar with the data in the usable map form that he has requested. It is undisputed
Where the agency has not said that the records it used for the investigation and the trial are no longer in existence.
Correct, Your Honor. The agency has said that the map images that it used at trial are no longer, that they were unable to locate those. And the DEA has not disputed in this case that it can readily convert the GPS data into map images. And by its plain language, FOIA requires the DEA to provide the data in that readily reproducible form.
So if we're talking about a piece of physical evidence, and the agency searched for it, or even a description of a piece of physical evidence that was introduced at trial, and the agency was unable to locate it, what would the result be?
If the agency conducted a reasonable search and was unable to locate it, then the requester would not necessarily be entitled to that information, but for the provision at issue here, which is 552A3B, and which entitles a requester to the form or format that he or she requests, as long as it is readily reproducible in that form or format. And here, the information at issue is the GPS tracking data, which presupposes a map. A map is simply another way of viewing, displaying, manifesting that very data. And in fact, that is why when the DEA was tracking Mr. Aguiar in real time, it viewed a map image of the coordinates. It didn't view a list of the coordinates, even though it has stored them in that way.
That's and so one idea, but another idea is simply a tracking idea. You know, if you're on a boat, where are you? And you write it down, but there's no map as such necessarily. I just want to be clear, is it your position then that the text of the statute is such that in my hypothetical of a written description of a physical piece of evidence, for example, a gun, the agency would be required to recreate that?
No, Your Honor. I think if you're actually having to change the substance of the information that the agency actually has, that would be creating a new record and would not be a form or format. So
I'm trying to make this hypothetical clear, and I'm not. If there had been a memorandum describing the gun that, let's say, was introduced at his trial, and now the government, a FOIA request has been made that's specific enough, and the agency has conducted a reasonable search and is unable to find either the gun or the memorandum describing the gun. I want to be clear what you think the law is in terms of what is the agency's responsibility regarding that request.
I don't think, Your Honor, that the agency would have to recreate that. I think the agency's obligations only extend to information that it has in its possession and control. And so here, the agency undisputedly has the GPS tracking data. It has it in one particular form. It has it in the coordinate form, but it is required to produce that in another form or format that is requested. And so I don't think that the agency is obligated to create information that it no longer has. But where it does have that information, the 1996 FOIA amendments make clear that the way in which the information is stored does not matter anymore, and the requester is entitled to his or her preferred form or format of that information. And so I do think that map images very easily fit into the statutory language here, for the very reason that the DEA regularly in its business views those coordinates in that very map form. And
do we have any reason to think that they ever use or view it in anything but the map form? I mean, no, Agent Carter talked about being able to view these maps and see these patterns of travel on Mr. Aguiar's part. And we also have pretty illegible copies in the record of the maps that were introduced at trial. Do we know whether they ever look at the numbers, for example, to see patterns, or look at it in the form that they provided it?
I don't think so, Your Honor. The DEA certainly has never argued that, and the record does not reflect that it does. What the record reflects is that when the DEA uses GPS monitoring in its business, it uses an interface now, a software before, that allows it to view that data in real time in the map image and not as a list of coordinates. And I think this is similar to a situation where now within the modern era of technology, agencies may store information in a way that is readable by a computer. For example, the GPS coordinates here, or a binary code. But then when they actually use that information in a way that's understandable to the human eye, it requires some sort of processing. And that is exactly what the GPS data here requires, and how it is intended to be viewed in the map form.
Help me here, and here's what my first question was all about. He asked for a CD from the DEA containing the DEA computer files of all tracking information collected via GPS devices between these two dates, about 6 months apart, the very same file used by DEA to prepare exhibits for trial. Isn't that what he got?
No, Your Honor. I believe his request, which must be construed broadly, was for all images associated with the tracking information. And the DEA, once it provided the CD with only the longitude and latitude coordinates, it has always been understood, as it was by the district court, that Mr. Aguiar's alternative request is for the agency to use its mapping technology to put that data into map form. And the DEA has certainly never indicated that that was not included within Mr. Aguiar's original request, or that his original request was not specific enough to require the DEA to put the images, to put the GPS coordinates into map form.
In your brief on page 30, you refer to the district court's decision taking the view that, quote, creating the maps would involve inputting data into a computer program to generate thousands of individual map images. And you respond that visual maps are required, but you never dispute the notion that thousands of images would be required. And one of the issues in contention is whether the agency is being called on to exercise judgment in creating new documents. And I had been assuming until I read that page that, and you didn't take issue with the characterization of thousands of individual map images, that what Mr. Aguiar was seeking was not one separate map for every ping, but a map showing all the coordinates of a particular journey.
That's right, Your Honor. Mr. Aguiar is seeking, he's not seeking a map for every ping. He would need to be able to differentiate the coordinates from one another. So it may be that it can't be that all the coordinates, I assume that it would not be that all the coordinates could fit on one map. It is not in the record exactly how many maps would be required, but certainly the DEA could produce maps that contain multiple coordinates consistent with Mr. Aguiar's request. And of course,
so the question is, I think the legal question for you is, to the extent that the case law says, differentiates an existing document from a document generated in response to a FOIA request, one of the factors that the cases look at is whether the government would have to use judgment in kind of creating new records. And what's your response to that on this issue, where obviously Mr. Aguiar would not find useful a separate map for each ping, and he also would not find useful one map with all the coordinates on it. So what's the unit, and why is that not requiring the DEA to make a new judgment that is essentially creating records for the FOIA response?
I think, Your Honor, the test for form or format is whether there's a change in the content in which it would not be a new form or format, or just a change in the physical attributes. And likewise, when we're talking about judgment, if the request requires the agency to make judgments or analysis about the content, like summarizing information, that's creating a new record. But if there's no change in the underlying content, but there may be some judgments about the physical attributes that have to be made, that does not take us out of the form or format language. And in fact, even under the DEA's narrower reading that is not in the text, that would limit it to electronic or non-electronic or coded or uncoded or the like, you would still have the problem of there's always going to be certain judgments about the type of CD or the weight of paper, or what kind of Excel spreadsheet or Google spreadsheet. And so a lot of times that will just be a factor of what the tools the agency uses to readily reproduce the document. And here, of course, the agency has not disputed that it could do so, and has not said here that really this request would require all kinds of judgments. Mr. Aguiar is only seeking that the agency use the tools to put the GPS coordinates into map form.
No, in fact, they don't seem to be disputing that. They seem to be preparing, if they lose, to give you thousands of individual map images, each with one ping.
I think, Your Honor, I read the DEA as saying that it would need to put enough maps that the pings would be discernible from one another. But I do think that judgment would be up to the agency likely, and I do think there's guidance in the 1996 amendment's purpose, which is to enhance the usefulness of information and use technology to make sure that requesters are getting access to information in usable form. So I think as long as the DEA is providing the information in a usable form that satisfies the requested issue, that would be satisfying the agency's obligation.
So it would satisfy its obligation if each ping were discernible but not mapped as a journey?
I think, Your Honor, what Mr. Aguiar is seeking here is just to see the GPS coordinates plotted on maps. And so I don't think that it needs to be, he has not requested that they be plotted as a journey, though he is again seeking it in the form that the DEA viewed it, and presumably that form and the way that it is presented at trial often includes multiple pings, for example, from the same day on a map. So I do think the form that the agency views it and the form that its technology would use presumably would have multiple pings on the same map.
So I had my hypothetical about the gun because I thought it was easy. I thought here, and the reason I went back to his original request was I thought the language he used was attempting to eliminate the concerns about agencies having to exercise judgment when he said I want exactly the very same file that the agency used. So the agency knows how many pings it put on a map, which ones it introduced, etc. So the argument, as I understand it, is that a map form is not simply another form or format. It's a completely new representation of information. And the agency is not obligated to do that. And I thought that was sort of the district court's concern, that Mr. Aguiar would be getting this additional information. What's the best response to that?
I think, Your Honor, that the test cannot be whether form creates or requires creation of additional information. And the reason why is because I think all forms inherently require additional information that is particular to that form. So for example, if the agency kept data sets but regularly produced them into graphs or pie charts, that would be other forms. Those need to add the pie or the X and Y axis. Those are sort of features, physical features that are particular to that form. Here, the GPS coordinates, which presuppose a map, which are simply the longitude and latitude, a position on a map, presuppose that there's a map that allows a user to understand the physical location of those GPS coordinates. And so as long as the information that is added is not altering or analyzing the content at issue, then it is simply another form or format where the added information is incidental to, is part and parcel of the very form that's being requested. And that is the case with a map. And here, the agency would read limitations into the statute that simply are not there. And it is undisputed that an agency, for example, would have to, print paper that's only kept electronically. And so, just as that's not creation of a record, putting the GPS coordinates in the way that the agency usually views them is not creation of a record.
So you draw the line at adding or changing information?
I would draw the line at whether you are changing the substance of the underlying information.
And as you just said, I believe the way the touchstone would be the way the agency ordinarily uses the data.
Yes, Your Honor. I think that in a case such as this one, where the agency ordinarily in its business uses the data in that way, it's very easy to see that the requested form or format fits within that broad any form or format language.
What do we know about the way, obviously we can ask Mr. Walker, but what do we know about the way the agency ordinarily uses the data? We have the trial exhibits.
Yeah.
But more, in Mr. Carter's testimony, he talks about referencing maps. Can you tell us, to the extent that you know, the specifics about where and how? Was it back at the office? Was it in the car? Was it on a smartphone? Just remind us what the record has on this.
Yes, Your Honor. I believe the Agent Carter's testimony was that he would view the maps in real time at a computer. I don't recall that he specified, but I got the sense that it was from an office. And so in real time, when he would want to request, a ping or send up, to the satellite to show the coordinate, he would view that on the computer and would view Mr. Aguiar's movements on a computer. And then, of course, in addition, in map form, would view them on a computer in map form.
Showing. I can look at a car calling app and see that my child has used my account to go drop a friend off and another friend and come home, and I see the whole trip. Do we know whether when Mr. Carter was looking, was he just seeing the car, or was he seeing that he had been down, Route 7 and across Spear Street?
He would see it for as many times as he put in the ping. So sometimes he was monitoring Mr. Aguiar around the clock. And so in that case, he would be putting in pings every minute or so, and he would see the car traveling somewhere, for example.
So he would only see what someone with a helicopter and a lot of time on their hands would see. He would see where the car was, as you say, in real time, but not the path, the journey.
Correct, Your Honor. The only way he would see the path is by, repeatedly pinging while he was monitoring and seeing the path in that way while he was monitoring. Does that make sense?
Yeah, but it's also different from the trial exhibits.
Well, yeah, correct, Your Honor.
Because there's no such thing now as producing, the real time. I mean, they could produce that, and they'd presumably show Mr. Aguiar's car in some impoundment lot somewhere.
Correct, Your Honor. So what Mr. Aguiar is seeking is the coordinates that the DEA has given him, the 351 pages that tracked his movements from 2009, plotted on a map.
On many maps.
On potentially many maps, the same maps, but potentially it would need to be, if they were printed, would need to be printed multiple pages. Yes, Your Honor. But of course, the DEA hasn't disputed that it can readily do that, and printing a large volume of documents is often required for complying with a FOIA request. And to your question, I think a second way that the DEA used the GPS coordinates was by, I believe the record reflects, putting them into a software and printing those images for trial. And that might be much closer to what Mr. Aguiar is requesting here. The agency, in fact, I believe the record shows that at least their old technology couldn't necessarily print from the same software that they were using in real time, but they would often put the GPS coordinates into a web-based interface and print it on Google Maps or the like, to again make those GPS coordinates readable and understandable to the jury and to the DEA itself.
Do you know offhand what happens when agency records are destroyed pursuant to agency retention standards and guidelines and rules and regulations, et cetera? So a lot of documents existed at the time of his trial pursuant to the standard federal government agency destructions timetable. They no longer exist. How does that affect Mr.
I don't think it does affect Mr. Aguiar's request, and I actually think, Your Honor, that that's exactly what the 1996 amendments were intended to cover, is a situation where an agency may only keep a electronic form of the record, as it did here. It only kept the GPS coordinates, even though that's not how it viewed the coordinates or used them at trial. And so even in that circumstance, the 1996 FOIA amendments make clear that regardless of the form that something is stored, a requester is entitled to it, and he or she is entitled to it in the requested form or format. And so here, again, Mr. Aguiar would be entitled to the map form, even though it is no longer saved in that form.
And what happens as a result of the fact that because he is incarcerated, he does not have the access that an unincarcerated person would have to a computer where he could ping and print?
I don't think, Your Honor, that an agency is required to consider the characteristics of the individual requester or the access they may or may not have, but I do think that Mr. Aguiar's situation does show exactly why Congress enacted this provision, because the GPS coordinates are meaningless to anybody. They're meaningless to the DEA. They're meaningless to a requester who has access to a computer, and the statute makes clear that it's that the DEA, that the agency is to maximize the usefulness of the information. And so for anyone, regardless of access to a computer, the DEA is required to provide that information in the readable, usable form that it itself views it.
Wait a minute, you say it's meaningless even to someone who had access to a computer. I assume that someone who had the resources, the time, could hire someone to plot these the coordinates come with a time specification, right? So they could plot these on a map, and it would be actually quite useful. As Judge Rogers said, if people are in the nautical world, they write down longitude and latitude, and it's precisely because that can be decoded, if you will, by reference to a map.
Yes, Your Honor. What I only meant to say that they're meaningless to anyone in their current form, and so some manipulation would be required, and some individuals may have the ability to do that, and that's why the statute provides the protection that the agency can pass direct costs onto the requester. So the DEA is required to put the information into the usable form that it does, but it can, of course, as long as it can readily do so, which is not disputed, but it can, of course, pass the direct costs of reproducing that information onto the requester. So I only meant to say that this current information, the way it is stored, is meant to be read by a computer and to put into the usual form that is readable by the human eye.
As Judge Rogers pointed out, the maps from the trial are destroyed. So at this point, unless someone there had a photographic memory and could remember exactly what those maps looked like, you're asking the DEA to take these coordinates and to plot them on a map. What if they produced a map of the world and it had every country labeled, but no more detail than that, and it plotted all these coordinates on it? And let's say that it zoomed in, and it wasn't just one map with all these 351 pages of coordinates, but however many pages you anticipate eventually being produced, let's say that is produced. But I think you're imagining a Google map that says, like, Broadway and Main Street and 2nd Avenue, but they don't give you that much detail. They just say, here's a map. It's a map of the world, and here are your coordinates plotted. That's not going to satisfy you, correct?
Correct, Your Honor. And to make sure I understand, it would be a map of the world, but it would be sufficiently zoomed so that you could tell the coordinates apart.
You could tell the coordinates apart, but there would be no streets, no rivers, no even state lines, let's say. So that's not satisfactory, and I understand why it would do your client no good, or at least it wouldn't do your client any more good than the coordinates themselves would do. But isn't the fact that is unsatisfactory, doesn't that suggest that what you want is more than coordinates plotted on a map? You want coordinates plotted on a map and additional descriptions of what's around the coordinates, streets in particular. And that's exactly what you're not allowed to ask for. You're not allowed to ask the agency to summarize or describe.
I don't think so, Your Honor. I think that all that Mr. Aguiar is seeking is the coordinates plotted in the map form that the same way that the DEA regularly does it, which presumably—
But we don't know how the DEA did it in the trial. I mean, nobody remembers exactly how much detail there was.
Correct, Your Honor, but using the tools that the agency has at its disposal now, it is in the record that it has access to a web-based interface that allows it to plot maps. And presumably, they're not of the world, and they contain street names and the like. And I do think that information fits into the sort of it is particular to the form of a map. So in the same way that if someone asked for a scatter plot, the agency couldn't give it without an X or Y axis or a scale. I think that information is just part and parcel of what makes it a map. Or if a requester asked for a native format of a document and the agency had both, I don't think the agency could wipe the additional formulas and the other kind of metadata that is part of the native format.
Let me ask. In my head, I have that there was a record before trial, the coordinates. The agency created a second record for trial, the maps with the coordinates plotted on it. That second record was destroyed. Now we only have the first record. And you're asking, this is how I'm viewing it. I know this is not how you view it. You're asking the agency to take the record that exists and to create a second record. And your argument is, well, they created a second record once at trial. So it's fair to ask them to create a second record again. But FOIA does not require an agency to create any new records. So tell me why I'm thinking about that wrong.
I don't think, Your Honor, that my argument is that because they created it once at trial, they need to create it again. My argument is that it is not creation of a new record when it is simply reproducing the same underlying information, which here is the GPS tracking data, in a new form. So the 1996 amendments say that regardless, the record at issue is the information, regardless of its form or format. So the record at issue here is the GPS coordinates, the latitude and longitude. That can be in a form of a spreadsheet, or that can be in a form of a map. And so the agency currently has the form of a spreadsheet, but has to reproduce that in the form of a map
But
image.
you told me earlier that the form of a map is not sufficient. It has to be in the form of a map with enough detail that you like it. But right?
I think it has to be in the form of a map with the characteristics that make a map form a map and make it recognizable as such.
Well, I mean, my hypothetical's map was a map. You know, there are a million maps of the world that just have countries on them. Let me ask one more hypothetical. Imagine that an agency has a document, 351 pages worth of it, and it has nothing but addition problems on it. So it has 2 plus 2, and the next line is 3 plus 5, on and on. And they turn this over to a FOIA requester, and the FOIA requester says, you know what, I want this in a different form. I want it to say 4 instead of 2 plus 2, and I want it to say 8 instead of 5 plus 3. Now, I think if I apply your logic, that FOIA requester should get his way, because all you would have to do is enter that data, 2 plus 2, 5 plus 3, into a very basic computer program. And that very basic computer program will spit out 4 and 8 and on and on and on. Would you agree that if we apply your logic to that hypothetical, the agency would have to produce a document that says 4 and 8?
I don't think so, Your Honor, or I at least think that's a closer question, because that requires some analysis of the actual underlying information in a way that this doesn't. The latitude and longitude are staying exactly the same, in the same way that a requester might not be able to ask for the mean, median, and mode of a set of data, but they would be able to ask for a scatter plot of a set of data. And so I really think it gets to whether the underlying information is being manipulated, or if it's just a different way of displaying or viewing that information.
I think that let's put ourselves in the days before there were computers, because in the computer age, both of the hypotheticals can be done in 2 seconds, I think. There's a program that already exists, and you just enter the data and it spits out what we're talking about spitting out, whether it's a Google map or whether it's the addition things. But back before there were computers, each of those, I think, would have required some analysis. I mean, it would have taken someone with math skills to figure out that 2 plus 2 equals 4. And it would have taken a cartographer or a navigator or an explorer familiar with cartography to analyze these individual coordinates and plot them with precision on a map. And, you know, history is full of explorers who weren't good enough at that and they got lost, you know? So how is it that your request does not involve the analysis that you think is not required under the statute?
I think, Your Honor, because the coordinates just sort of presuppose a map, the longitude and latitude, although it might require, you know, if someone were doing it by hand, finding that spot, it is all that those are showing a position on a map. Whereas when you're talking about adding numbers, I do think there is a certain type of creating a new type of content if you're talking about then adding what all of those numbers add up to.
If I gave you the two sets of data, the coordinates and the addition problems, and I also gave you an atlas, which do you think you would be able to do easier? Plot the coordinates or do the math? Surely the math, right?
That does seem right, but I don't think that is the test for form or format. I think it's
I'm trying to get the test for analysis. How much analysis is required?
Correct, but I don't think the test is whether the analysis can be done easily or automatically or not. I think it's just whether you're having to really kind of manipulate that data. And I will grant you that that is a tougher question, because I do think that if an agency were to, for example, store images in binary code, it would need to produce the image that binary code would show. And obviously that's something that a computer could only do. And I think that is what the purpose of the 1996.
What's the answer to that? Let's say the computer has it in binary code. Does the FOIA requester wants it in something more user friendly?
Yes,
the FOIA requester wins that case.
Yes, I believe so, Your Honor. I think that's exactly what the 1996 FOIA amendments require, is for the agency to provide it. Surely they are viewing the image in the readable format and would need to provide it in that usable form to the requester.
Okay. Thank you very much.
I just have
from me.
From the government.
Wait, I just had one more question, if I might.
It's already been 30 minutes here, so.
I'll ask you on rebuttal.
Okay, great. Thank you, Your Honors.
Counsel for the agency.
Yes, good morning, Your Honors, and may it please the court. I'm Assistant United States Attorney Johnny Walker, arguing on behalf of the Drug Enforcement Administration. I want to reorient to what Mr. Aguiar actually requested in this case, because it's actually very specific. It's not just any map. What he wants, as Judge Rogers noted, is the images and proprietary software associated with the information collected from the GPS device from January 23rd, 2009 through July 30th, 2009. The very same file used by DEA to prepare exhibits by trial. And he makes clear in the preceding paragraph of his FOIA request, and this is at JA 105, that he is looking for the exact data and images that DEA monitored while agents were tracking his vehicles. And in his FOIA appeal to the denial of that request, which is at JA 114, he makes further clear that he is looking for a corresponding satellite image plot for each ping on Google Maps at the lowest available altitude between 50 and 100 feet on the versions of Google Maps in place at the time the GPS tracking of my vehicles was performed by agents in 2009. So what Mr. Aguiar is looking for is very specific documents. He wants Google satellite images showing the pings of his vehicle, the very same images. You may not even be able to characterize that as a map, but the very same satellite images of his vehicle that agents viewed in 2009 while tracking it.
Oh, it's not vague. It's very specific.
Correct.
The agency knows exactly what he is seeking because he has described it with such great particularity. But he doesn't have access to this one translating machine that he needs. And so the statute says, pay for it, you can get it in a different form.
I think, Your Honor, well, what the statute says is that you can have records that are in the agency's possession, custody, or control. And these are images that the agency no longer has. It conducted a search, the adequacy of which is not disputed, and it did not locate these images. What Mr. Aguiar is asking the government to do is to make them. He wants these images that the DEA saw. The DEA doesn't have them, and so he is requesting that the DEA create these images anew for him. And that is the creation of a record, plain and simple. And it goes against decades of FOIA precedent that this court has recently affirmed, by the way, in a case that postdated the briefing in this matter. And that's National Security Counselors versus CIA, 969 F3rd 406, 2020 DC Circuit case from August, in which this court cited the long line of precedent from Kissinger to Forsham to Sears Roebuck to Yeager, emphasizing that an agency is not obligated to create records. Now, what amicus must argue then is that generating these Google satellite images is not the creation of a record. And amicus acknowledges that I think her quote was that a change in the substance of information associated with a record is not a reproduction. It's not another form or format of the record. And that's exactly right. But there's no way that you can contend, I think, that a satellite image at a given location in time does not add to the substance of a longitude and latitude pair of.
Let me ask you, Mr. Walker, some kind of technical questions, facts questions.
Certainly.
If we ordered you to do what Mr. Aguiar wants, in my head, I think it is this simple. But tell me if I'm wrong. You pull up the document with the 351 pages of coordinates. You select all. That takes a second. Control A. You copy. That takes another second. Control C. You go to Google Maps. That takes another second. And you paste. Control V. That takes a fourth second. You press enter and it pops up on the Google map all these coordinates. Now, I've never done anything like this. What I think might take 5 seconds may actually take 5 minutes or 5 hours. And I guess, am I wrong? And if I'm wrong, walk me step by step how you would comply with the order if the order were what Mr. Aguiar wants.
Frankly, Your Honor, there's nothing in the record that indicates there is any way to comply. Even if the DEA were able to.
Well, you did it at trial, right?
Well, the U.S. Attorney's Office presented evidence at trial, and what Agent Carter testified was that he assisted in the preparation of those exhibits. Those were not prepared by.
Well, how is it readily reproducible? Let me ask that. The district court said that you conceded this is readily reproducible. Is that district court statement correct?
No, we have not conceded it's readily reproducible. Our argument
is it readily reproducible?
All indications are that it's not, Your Honor. The exercise that you just laid out, where these are cut and pasted
into. You contest that in your appeal. You didn't say the district court got that wrong. Do you think that you forfeited the argument that you're now making?
No, Your Honor. I mean, the record shows.
Why didn't you contest it in your appeal?
Because our position, Your Honor, is that this is the creation of a new record, which is not.
I get that, but to the extent the question of whether it's readily reproducible might be informative, or a more straightforward way to decide this case, I'm just kind of wondering, as a strategic matter, why didn't you say the district court was wrong?
Well, it's in the record, Your Honor. I think, assuming that the DEA could undertake the exercise that Your Honor described, where these coordinates are put into Google Maps, and I know from my own personal experimenting that you can put a longitude-latitude pair into Google Maps online, and it will show you the location on Google Maps today, and you can get the satellite image today. But what Mr. Aguiar is requesting are the very same images that were viewed in the DEA's tracking program. And what we have in the record is that tracking program does not permit for the agency to put in a latitude-longitude pair and to generate an image, that those images are viewed in real time. We also know that program stores data associated with it for 1 year. Now, Mr. Aguiar's vehicle was tracked during the first half of 2009, and he submitted his FOIA request in 2013. So the underlying data here, frankly, was not even available to the DEA when it conducted its search.
So, I just want to, am I understanding this right? That if you, I know you don't want to lose. I'm not even saying I think that you should lose. I'm pretty skeptical of Mr. Aguiar's statutory argument. But if you lose, and there's an order that says you have to do what Mr. Aguiar wants, you're saying that the DEA can't do it. They're just going to be in contempt of the court's order?
The DEA would not be able to do it, as far as I know, Your Honor. The further we got with that, the furthest the DEA got with that, is it began to engage an outside contractor in an effort to try to produce the images that Mr. Aguiar saw. So it engaged an outside contractor, provided them with the data, and it got a quote that an estimated $608 is what it would take to start producing those images. I don't know if those images would be exactly what Mr. Aguiar wanted, or if they would comply particularly with this FOIA request, because nobody got that far because he didn't prepay the costs.
All right, but with all due respect, you haven't made the record to support your argument.
The record is there, Your Honor. The record does show that the
said, we will give you the maps if you pay $608. That's the case we have before us. And we're not, talking about some other case. Very specific request The agency's response is pay $608. You can have your maps. We know what you're talking about because we used them at trial.
But
I mean, don't we have to, doesn't the court at least have to deal with the case as it's presented to us?
Certainly, Your Honor. I mean, but if the question is are these maps readily reproducible by the DEA? The answer is no. We know that the
agency was misrepresenting to Mr. Aguiar when it said, pay us $608 because we have a contractor who can produce the maps as we understand your request. I mean, with all due respect, counsel, whether you win or lose, I mean, don't we have to stay within the record? There's no suggestion that DEA was misrepresenting the cost to Mr. Aguiar. The argument in the briefs was, well, he didn't want to pay.
I think the cost, even the cost that was provided to Mr. Aguiar was an estimate. They did not get so far as to say this is exactly what will be produced and it's exactly what will be required. There was a cost estimate provided to Mr. Aguiar based on the DEA's consultation with an outside contractor.
Do we know, Mr. Walker, an estimate for what?
Not exactly, Your Honor. It was to reproduce images. We know that it had something to do, that it was an audio-visual contractor and that the estimated cost was to produce images.
You got a bid to do something, but you don't know what the something is?
I don't think, it's not in the record, Your Honor. There was, all we have is the letter that was provided to Mr. Aguiar saying that that was the estimated cost that he would have to prepay in order to engage this contractor. The contractor never began any work or articulated precisely what would be produced. Now, I would note, Your Honor, I mean, this all gets past the argument that the DEA is making, which is that what's being asked in the first place is the creation of a new record, which goes against decades of FOIA precedent and is not required at all by the FOIA statute. What the DEA was offering.
Counsel, what would happen in this hypothetical? Somehow, Mr. Aguiar gets his criminal case before the Supreme Court. The Supreme Court sends it back for a new trial. The U.S. Attorney's Office has to figure out what is it going to do. It decides it wants to retry him. So it works with your agent to produce the evidence it needs for trial. I mean, we're not in a never land here, except for the hypothetical that the Supreme Court's going to reverse the underlying criminal conviction. But don't you have to deal with it in that sense? What would the agency do? We don't have a record that shows it's impossible for the agency to introduce the type of evidence that it introduced at his original trial.
That may be so, Your Honor, but as a legal matter, the agency does not have to create all records that's possible for the agency to create in response to a FOIA request. So
I understand that, but I just want to get past this hypothetical you're dealing with, that they couldn't do it. That is not the record we have before us. Whether they legally have to do it, for all these reasons the district court gave, for all the reasons you give in your brief, that's a different question.
Certainly, Your Honor. I'll put it this way. There's no indication that the DEA could do it using tools available to them. The only record that we have on this instance is that they had begun the process of consulting with an outside contractor, got an initial estimate, and that was an amount that Mr. Aguiar did not pay. And even amicus acknowledges that a requester can be asked to bear the costs of records, assuming that would be a requirement under FOIA for the DEA to engage an outside contractor to create records for a FOIA requester, which we strongly do not believe is the case. But even if that were the case, amicus acknowledges that that is a cost that can be passed on to the requester, and here the requester did not pay the cost.
So it's not as clear to me as your characterization suggests that the offer was made to Mr. Aguiar, you'll get the maps you want if you pay this amount of money. It's the record we have is is much more vague about what that $608.25 would produce. It's processing by an outside contractor.
That's right, Your Honor, which is why I'm hesitant to say that this was something that would satisfy Mr. Aguiar's request. Because we're certainly, so that these do seem to be sort of initial consultations with the contractor and a preliminary price estimate that was provided by the contractor.
Right. So to me, what's difficult about this case, and the questions by my colleagues have really been helpful in highlighting this. This isn't a situation where, you know, the agency wants to have the arithmetic math sheets and some requester says, oh, it would really help me if I had like the answer key. Will you add it all up? The way, and really the only way, the agency uses this information is as a visual representation on a map. That's the only way the agency uses it, as far as I can tell from the record. And so to the extent that it's retained this information just the way my computer retains ones and zeros on all the documents that I want to work on. And it just wouldn't make sense that I could give sheets of ones and zeros in a FOIA request if I were subject to FOIA and say, those are the documents that I have. And I think it's complicated, frankly, by a couple things. One, that the software is no longer licensed. So if I had an old computer, you know, and I really did only have the zeros and ones, you know, what would my obligation be in producing? But to me, the strongest case for Mr. Aguiar is, you know, presumably in preparing for trial, the agent and the AUSA looked at days and days and days of journey maps. You know, and here he did this on this day. The next week he did the same thing, and he stopped at Farrell Street, and he went to the Casella Waste, and he, you know, again he did this extra stop in wherever it was, Malden, outside of Boston. You know, and they looked at the maps to see the regularity, and then they decided which ones to print for trial. And what Mr. Aguiar wants is that same look, because presumably the AUSA printed only those that the AUSA's office thought was going to make their case, and he wants to see the rest of it. And so the use in the ordinary course, the only use is as mapped. And to me, that seems to distinguish this case from a lot of the other record production cases. I'm not sure it gets them all the way there, but what's your best answer to that narrower view about why this might not really be creation of a new record?
Well, Your Honor, I think what the cases make clear is that it's not only that agencies are not only not obligated to create new records, they're not obligated to retain or recreate records that once existed. And so while yes, it is true that the DEA did view maps on a computer that were generated in real time as a result of this GPS ping. That was in 2009. And there's no dispute that those ping reports, those satellite images associated with those pings are no longer available to the DEA. It no longer has them, and it did not find them after conducting a reasonable search. And it is just as much not an obligation of the DEA to recreate or retain a record as it is for it to create a new record. I'll note that Your Honor is absolutely correct that there, you know, technically every PDF document is stored on a computer in the form of ones and zeros. But at the end of the day, the expression of that is a PDF document. I mean, this is exactly, I think, what the eFOIA amendments were meant to clarify, is that a record that is stored on a computer as an electronic record is nevertheless still a record. But that's certainly not the case here. This is not an instance of the DEA trying to be cute with, you know, a record just because it's electronic is not a record. The only information that was located here, and frankly, that spreadsheet of coordinate data was not even located in the DEA's own search of its field office and the investigative files of Mr. Aguiar. It went to the U.S. Attorney's Office to obtain that spreadsheet of data. And that is the record at issue here. Now, nobody's saying because that's stored electronically or because that ultimately boils down to ones and zeros, it's not a record. What we are saying here is that the DEA is under no obligation to take the content of that record and create a new record of significant supplemental and additional content. As Amicus phrases it, a change in the substance of the information.
That's actually that's helpful because it did seem like the U.S. Attorney's Office would be the likely situs of map information. So as I was imagining, Agent Carter sits with the Assistant U.S. Attorney, and they pull up this data through some software interface and look at a bunch of maps, and only a small subset of those are printed out and used as exhibits. And I guess the question is, what do we know? And it's probably in the record. I should have a more precise recollection of this. But what do we know about Judge Rogers' question? Were the U.S. Attorney's Office confronted with the requirement to retry the case? Your position is they'd have to hire an outside contractor to print maps.
I frankly don't know, Your Honor, what they would be capable of in terms of the data that's available. What we know about what happened in the case the first time around is, as you say, Agent Carter testified that he assisted the United States Attorney's Office in the preparation of exhibits for trial. We don't know what actually went into that preparation. Actually, the DEA attempted to find out in response to Mr. Aguiar's request. They tried to contact Agent Carter, who at that point was retired, and they were unable to do so. So all we know is that he somehow assisted the U.S. Attorney's Office in creating these documents that are exhibits at trial. And essentially what Mr. Aguiar is asking the DEA to do is to do the same thing for him. But because that is the creation of a new document, it's not currently in the DEA's possession. It's outside of the bounds of the FOIA requirement.
Go ahead. We don't know whether, if the U.S. Attorney's Office were asked, can you log onto a computer today and pull up this information as, plotted on Google Maps, let's say a separate map for every journey. We don't know whether they could do that in-house.
U.S. Attorney's Office, we do not know. The U.S. Attorney's Office could do that in-house.
Do you know if DEA could do it in-house?
Or they can't. You don't know.
We don't know.
Do you know if the DEA could do it in-house?
It does not appear that they can, Your Honor. We know that the tracking device software that they use does not permit inputting coordinate data and generating a map.
And they didn't do it the first time. Either the U.S. Attorney's Office or an outside contractor did it the first time in 2009, correct?
It appears that way. Agent Carter did not testify that he created these exhibits. It was not the DEA who presented them at trial. Agent Carter testified that he assisted in the creation of these exhibits. He did note that the pictures that we look at, the individual maps with the ping reports on them, he did note that is, he called it a screenshot. So that is what he sees when he's looking at the ping reports in real time.
And this is a very small point, but did you say that the DEA had not been able to find Agent Carter, retired Agent Carter?
It attempted to contact Agent Carter and was unable to contact him, just to ask how these trial exhibits were prepared. That's correct.
I mean, it's a law enforcement agency. It seems like it, tracks down fugitives and stuff all the time, but I don't have any more questions.
I don't know that they brought quite the same resources to bear in tracking down Agent Carter as they do in tracking down a
That's fine. It's fine.
In terms of the request was made of the DEA, but they nonetheless also sought information from the U.S. Attorney's Office. What's the nature and limits of that obligation?
I don't think there is any obligation, Your Honor. I think this is just something the DEA did in order to try to satisfy a FOIA requester's request for documents. I think the same is true of its attempt to engage an outside contractor to try to create these images. There's no obligation in FOIA that the DEA create images, but I think it went above and beyond its obligations in trying to find a contractor that could do that.
So what I was going to say is that under FOIA, the assumption is the records will be turned over unless the agency can invoke an exemption or some of the case law. And Kissinger was decided a long time ago, and we have a whole new development in the world of communication now that the statute acknowledges. So the statute itself has already increased the agency's burden when something is readily producible in another form or format. So as Judge Pillard suggested in her question, if the only reason that this raw data that was turned over to the requester was in an effort to provide him what he wanted, I don't know necessarily the sequence, but this is not a case where the agency has told us there is no way this can be readily reproduced. In fact, what we had here was a contractor who was proposing to do this for us for $608. So the question in my mind is, in that fact scenario, if the agency only has this information for one purpose, and that's precisely what it used it for in connection with Mr. Aguiar, then what is the agency's burden here? How is it going to define form or format where the agency doesn't have this list and only uses pings in connection with maps? What should given arguably the plain text of the statute and Congress's increasing determination to broaden access to government information that is outside of these exemptions, why wouldn't this court ask, absent the agency making any statement that it's impossible to do what Mr. Aguiar wants, and we're going to make him pay for it anyway, and if he wants to pay $5 million to get somebody to do this translation, so be it. But the legal question would be, what is he getting that's different than what the agency itself has the information for? Don't we have to come at the question that way?
I think, Your Honor, the way to come at the question is not what the agency is capable of creating, what records the agency is capable of creating or recreating that once existed. Because a long line of FOIA precedent, as I say, affirmed by this court most recently in August 2020, is very clear that FOIA does not require the agency to create, recreate, or retain records. So the question is simply, is the exercise that Mr. Aguiar asking the agency to do, does it require the creation of a new record? Now, what he wants are thousands and thousands of images on a Google satellite. He wants Google satellite images from 2009 that the agent looked at when it was tracking its vehicle. And each of these.
I guess what I'm trying to get at is this case is a little different than the other cases. And that's what the whole amicus brief was all about. That's why the court, I assume, appointed amicus, to get at this sort of cutting edge and decide where this case falls. And you can agree with the district court that putting on the information about what Judge Walker talks about, the rivers, the streets, the stores, that's creating an entirely new record. And the agency has no obligation to do it. So if Mr. Aguiar wants to get this information, the only thing he can do is, and I don't know whether criminal defendants even have the authority to do this, is to enter into an outside contract for a translator so he can get these Google Maps. And one of the questions I was thinking about, okay, you don't look at who the requester is, but do you look at it in terms of, can the information the agency turns over be of any use? It clearly isn't the use he wants. That's not what he's asking for. He wants these maps. And so what is the agency's burden to show? I understand if the agency can show there is no way it can do this, irrespective of whether it has a legal reason to do it. But that's not the approach that's taken here. And how do we draw the line? And counsel, amicus offered some lines, and I was waiting for you to come up with your lines.
Well, Your Honor, luckily, we agree with amicus that the line is at least that a new record involves the change in substantive information to the record that is quote unquote being reproduced. Where we disagree with amicus is that a Google satellite image from 2009 showing time location has a different substance, materially different substance, from an Excel spreadsheet of longitude and latitude numbers. So I think amicus's assumption is built on this notion that there is no difference, no substantive difference in content between an Excel spreadsheet of longitude and latitude numbers and an actual satellite image from a given point at a given place at a given time.
That seems, I mean, and I get it that the request, the very specificity of the request, which frankly, you know, looking at it retrospectively seems a bit misdirected because there's no such thing as real time in retrospect, right? So I get it that there's a technicality there that invites you to view the request with a similarly technical lens. But stepping back from that, presumably there's just a standard that the U.S. Attorney's Office uses day in and day out, you know, when they're looking at drug transactions in the such and such a court in the such and such a neighborhood in DC, that is illuminating, you know, that they take this kind of information and they're like, okay, we want to see basic street level. And it's not like new roads have been built in this area, like, you know, so the fact that it was 2009 and now it's, you know, to me, the thing that distinguishes this case is that there's a kind of everybody knows what he wants and what's useful to him aspect to it. And indeed, I find myself wondering, was the tracking information as was available to the U.S. Attorney's Office to review in preparation for trial and to select, why was the full amount of all that information on, let's say, daily maps not Brady material? If I were Mr. Aguiar and, you know, it's thinking like, what, why are they seeing this? You know, I want to see it in context. That wasn't Brady material to say, okay, here's all the information we have about all your trips, and here's what we're deducing.
We don't know that actually the DEA ever retained or created or had in its records every image of a ping report. Certainly there were probably times when, I mean, these devices were attached to Mr. Aguiar's car for a very long period of time. Sometimes they were sending reports, you can see in the example in the records, sending reports every minute. So there's no indication the DEA saw every image or that that every one of those images was actually retained somewhere. What we know is that the images that were presented at trial and numbered as exhibits, that Agent Carter assisted the United States Attorney's Office in some way in creating those. And what
Let's say that what was retained is just I mean, we do know that what was retained is at least the information in the spreadsheet.
Correct. Agent Carter did testify to that.
Right. So what I'm saying is that if that could be, and presumably was, flipped through as a series of maps to select the ones that lawyers wanted to use at trial, there were some that were not selected. And what I'm asking is, at the time of trial prep, why wouldn't that have been Brady material, or was it?
So I don't know that was the case, that there was a series of maps that were flipped through and selected and that others were not provided to Mr. Aguiar. I do know what Mr. Carter testified to. Agent Carter testified that he described the images that were admitted as exhibits as screenshots. So one possibility is that Agent Carter took some action to actively take a screenshot of his screen, whatever screen on his computer he was using to monitor Mr. Aguiar at certain opportune or significant moments in the investigation. But there is no indication that actually all of these maps were collected and all of them were gone through. Frankly, that there would be many of them, as every indication. There are 351 pages of that spreadsheet that were produced. The first one, which is in the record, I count 46 entries on it. By math, that comes to about 16,000, well over 16,000 individual coordinates that are likely on these spreadsheets. So that would be many, many, many thousands of maps.
Right. I'm looking at, so am I right that, for example, JA 96, maybe 92, 93, 94, 95, that those are the screenshots? And that JA 97, which shows the more of what I've been referring to as a journey, that would have been one of the exhibits. So the 68D, exhibit 68D, that's JA 97, is different in kind from the more oblong, darker ones, which frankly we can't even see. So some are screenshots and some are not. Do we know that or not?
It's not crystal clear in the record, Your Honor. Agent Carter does use the word screenshots to refer to the darker oblong images that have sort of the little, the speech bubble with the report date, report time, etc. And he does testify that he worked with the United States Attorney's Office to create some exhibits for trial. So I would assume that the sort of Google Maps showing, point A to point B in a route were created through some other means other than the monitoring program that the DEA was using. That is my understanding.
And no particular comment one way or the other as to whether there's any Brady aspect of this information.
I don't know, Your Honor. I certainly don't know that there would been any Brady violation. Like I said, I don't know that all these maps existed. I don't know what was provided to Mr. Aguiar as Brady material. I do know what he's certainly looking for now is all of the images. And as I said, there's no indication that those ever existed.
All right.
All right, if there are no further questions, I'll conclude by asking that the district court's judgment in favor of the DEA be affirmed. Thank you very much.
Thank you. So, amicus, we'll give you a couple of minutes.
Thank you, Judge Rogers. Just a couple clarifying points. The agency has never argued that Mr. Aguiar's request here does not cover the GPS coordinates plotted on maps using the technology at the agency's disposal. It has never said that that Mr. Aguiar's request was not specific enough to request that. And of course, if it had felt that way, its regulations require it to go back to Mr. Aguiar and ask for a more specific request. So the request issue here is just all Mr. Aguiar is asking for is for the 351 pages of GPS coordinates to be plotted on maps using the technology that the DEA has. And on that point, the DEA has never disputed that the maps are readily reproducible. There have been 6 agency affidavits. It has been up to this court already once. Never has the DEA said that it could not readily reproduce the map images, and that argument is forfeited. and we cross-moved for summary judgment, of course, and the DEA in its response did not say that that they were not readily reproducible. And it is all over the record that there is commercially available technology for doing this. And in fact, I heard Mr. Walker to say that that the record suggests that the agency cannot put in coordinates and print them, and that is in fact not in the record. If he was referring to the Roy Declaration at page 109, that only says that the past technology that was used to monitor could not be used to input coordinates, but not that the current technology has the same limitations. And of course, it's been admitted that there, if not that monitoring technology, then other technology can be used to input coordinates and readily reproduce the maps Mr. Aguiar is requesting. As to the $608 fee, the letters at Joint Appendix 106 and 111 show that that fee was for initial processing. The agency learned only after Mr. Aguiar sought a fee waiver that it was for the the agency only learned after Mr. Aguiar sought a fee waiver that the CD contained spreadsheets. And so the agency has never offered to reproduce the maps for any fee.
Ms. Fossil, can you answer the question I asked Mr. Walker about just the logistics? Is this really as simple as copying and pasting?
The record does not reflect that, Your Honor. I do think that it could be as simple as putting a bunch of the spreadsheet in at once, and yes, copy and pasting. It could be as simple as a click, but the record does not reflect that clearly.
And one more. What do you think is the least? I know you can't know exactly how many pages this would be printed out with the stuff plotted. 16,000 coordinates. It won't be 16,000 pages because there'll be multiple coordinates on a page, but you can't fit all 16,000 on one page. What is the least amount of pages that you can imagine this resulting in?
I think, Your Honor, it's at least imaginable. I believe there are around 50 coordinates on a page. I could see those potentially fitting all on a single map. So that would be around 350 maps. Maybe there could even be more fit.
That doesn't make any sense to me. And I feel like you're asking for something that will be supremely frustrating to Mr. Aguiar. Wouldn't he want, and I keep saying this, and maybe it's just in my own fevered imagination, but wouldn't he want a separate map for every actual journey? In other words, if you plot today's driving and tomorrow's driving and the next day's driving and the next day's driving on the same map, you're going to get like an Etch-a-Sketch in the hands of a 2-year-old. It will be incomprehensible.
I think, Your Honor, maybe I'm misunderstanding. I think that would essentially be what, for example, 350 maps might look like, because the Agent Carter could set up the pings to be happening every minute, and so it would essentially look like a journey for that day potentially.
But if you're not careful in saying that a separate day needs to be a separate map, you could get, as I said, a kind of a, over and over and over and over, all mushed together, and it would be non-informative, which is why for my comprehension, it just seems important to think about how the government actually uses maps and electronic tracing information. They do this all the time, This is not an exotic kind of information. And I'm guessing that they never pull it up as a list of coordinates. They pull it up as maps. And they never pull it up as 10 days or 100 days maps all on one sheet of paper.
I agree, Your Honor. I think we're starting with Mr. Aguiar's request, which does not contain that level of detail, but which I think has to be, when we're talking about whether something is a different form or format, that has to be read against the purpose of the statute to, which is in the purpose provision to maximize the usefulness. And so here it's easy to see what the agency would be required to produce because it's the form that they themselves use it. Just as you said. The way that we know we can see from from the record, from the maps in the record, what something like this would look like, and the way that the agency usually uses this information, and in fact, exclusively uses this information as far as the record shows. So yes, I don't think that I don't think the agency would be fulfilling its obligation by providing something that's a mush or unreadable. It needs to provide it in the form that it commonly uses them. And to the extent that there are difficult questions at the outskirts of what is a form or format, this case easily fits within that broad any form or format language, because we know exactly how the agency views these coordinates to make them readable. And I don't think that, Your Honors, that Mr. Walker has proposed a test to put the limits that he would read into electronic and non-electronic into that any form or format language, or the like, coded or uncoded, zipped or unzipped. I simply think that those limitations do not exist in the any form or format language, and the protections in the statute, the readily reproducible, where the agency is entitled to substantial weight on that opinion, and the fact that it can pass on fees, those are the protections for the agency. It's not by reading limitations into the broad any form or format language, where we know the Congress was trying to provide access in the most usable way.
All right, thank you. We will take the case under advisement.
Thank you, Your Honors.
Case number 20-1047 et al. Nalini Kapur et al. Appellants versus Federal Communications Commission. Mr. Corbett for the appellants, Ms. Citrin for the appellee.
Good morning.
Good morning. Thank you for hearing this case. I am Dennis Corbett for the appellants Nalini, Rishi, and Ravi Kapur. We appreciate this opportunity as the last case on the court's oral argument schedule in calendar year 2020. I am actually glad for the opportunity to wear a coat and tie. Such chances are few in a pandemic. This is a case brought to this court pursuant to your exclusive jurisdiction under Section 402B of the Communications Act to hear FCC licensing cases. We seek review of what the record shows to be unsustainable FCC failures to fulfill its obligations under Section 309 of the same Act. 309's requirement of a hearing is satisfied when we present one or more substantial material questions of fact before the FCC in a licensing case. Such questions, of course, proceed from record evidence.
Mr. Corbett, before we get to the merits, I want to talk about the possibility of mootness. As I understand it, you're asking for a station to be taken away from a company, OTA, that no longer owns it, and returned to a company, your client's former company, that no longer exists. How is that not a moot case?
For the reasons we set forth in the reply brief, to take the sale to TV 49 first. The record of the case makes clear that under the licensing scheme of 309, these cases can take time. I have followed the statutory roadmap in every case, whether it be reconsideration, applications for review, et cetera, which I must follow in order to get judicial review secured. During that period of time, if the target, OTA in this case, elects to sell the station to another party, in this case TV 49, which elects to buy it, subject to the cloud on the title, which of course this case puts there, and which the FCC acknowledged in the decision, then all those parties are subject to unwind, including TV 49 and including OTA. That's boilerplate. That's got to be the case for a case like this, for this court not to be deprived.
Who would we return the station to?
Well, that's the next question, to KXT LLC. That's a matter of California law, which was raised by the government in their brief. And in fact, it's a California dispute as to whether KXT LLC continues to exist. But the statute to which I cited the court, California 17707.06, makes clear that even if KXT attempts to unwind or dissolve, that it continues to exist for all purposes relating to that unwind. And in this case, Your Honor, OTA and KXT are parties to a signed unwind agreement by which they agreed in the event of a judicial overturn of the grant to OTA that they would unwind the transaction. So it's all buttoned down, it's all signed and agreed to. And the FCC acknowledged.
So we can, I mean, at the end of the day, assume that KXT does not exist. At the end of the day, you think that the station can still be returned to a company that does not exist.
The statute provides that it continues to exist, Your Honor.
Okay, and so I will go read it, the statute again. Can you remind me what statute?
It's California, it's 17707.06. We have a copy of it in the addendum to our reply brief. So you don't have to look, you can find it there.
And then the second buyer, the company that OTA sold to, TV49, they're not a party in this case. And so I wonder if we in the FCC are allowed even to do what you want us to do without any kind of due process violation, or whether TV49 is, a party that has to be here before we can take their TV station away from them.
Again, they elected not to. Before I get to that question, I wanted to point out as well, there's another provision in the California Code that says no action or proceeding shall abate by reason of winding up or dissolution. That's also directly relevant to your question. There are two provisions in there, both the continuation. As to TV49's election not to intervene, that nothing prohibited them from doing so. But were
they served?
Yes.
Is that in the? Can you tell me where in the record that is?
I can't give you a cite to that. That was as part of the service of our original petition.
Okay.
And but the commission put TV49 on notice of what every applicant before the FCC to acquire a station license knows, namely that the FCC grant of the assignment did not require closing of that deal, and that they closed at their risk, subject to the cloud on the title, which was the long pending claim by us that OTA lacked qualifications to acquire the station in the first place. So that's merely a risk assessment by TV49.
And then if everything were to go your way, if all of these legal questions were to be resolved in your favor, and then the station goes back to the original company, what happens then?
That's all part of that company then holds the license again, and it would be part of the long winding up.
But the majority owners of that company can still sell the station. Your clients are still minority shareholders. So even if you get everything you want from every court in the 32 FCC filings that you've filed, plus appeals and state arbitrations and state litigation, you get everything, then, and this goes to redressability and standing, you're still a minority shareholder in a company that's going to sell the station.
Well, we don't know that, first of all, Your Honor, as to what they would do. Secondly,
you seem pretty committed to selling the station. You've fought them for, a while now. But okay,
But I would suggest, in response to your question on standing, just as I cannot establish standing in this court on the basis of a hypothetical injury, which I have not. I've argued a concrete injury through the loss of a unique investment. This court cannot deny me standing on the basis of a hypothetical lack of injury down the road by something that may or may not happen. So I can't be whipsawed by hypothetical on the front end and then thrown out of court on the back end on the basis of a hypothetical.
Mr. Corbett, you said that you have a concrete injury through the loss of the concrete injury to your clients at the time of the original sale to OTA was what?
The loss of a unique investment in the station.
But they were compensated for that, no?
Well, as it's a unique it's a unique asset, as we cited in the brief.
Right. So the LLC owns a unique investment, and the majority decide to sell it. The minority shareholders object, and that was arbitrated about whether there was authority to sell. And that's been finally determined that there was authority to sell, right? And in fact, your clients were compensated for the sale of that investment and their proportional, the value to them of that investment, right? And
actually, Your Honor, we have not been compensated.
No compensation whatsoever.
I believe there's a small amount of compensation to Rishi Kapur. Other than that, no.
And why is that, if they're shareholders?
That's a bit complicated, Your Honor, other than...
In this case, a bit complicated? Hard to imagine.
I appreciate that. The record does show that there was an escrow agreement created at the time of the original closing in 2014, and the money, the consideration was put into that account. At the same time, the unwind agreement was entered into. While there has been some distributions, my understanding, to the majority shareholders, not necessarily a fact of record in this case.
And that's because the Kapurs refused to accept because they were afraid that it would affect the harm to them, or that it would affect their ability to pursue a live claim?
Again, I want to be careful about my representation of the facts concerning the lack of consideration. It's been a contentious matter throughout. It continues to be, in terms of the release of the consideration to the Kapurs from the original sale. And I think to go beyond that, I'm a little reluctant, if only because I want to make sure my representations of the court are accurate. I can say it's a byproduct of a long contentious matter, and we have not.
Let me just back up. It's your burden in a situation like this to show an injury. It's your burden to persuade us that your client was injured. In the ordinary course, a non-majority shareholding stake is not in control of the sale decision, but does get pro rata remuneration when the business is sold. That would be in the ordinary course. And you're claiming here that nonetheless, assuming, facts that aren't in evidence, but just to understand, that nonetheless, these minority shareholders would have preferred that the business not be sold, and that the law, the FCC character requirement, redounds to the benefit of the minority shareholders? Do we have any reason to think that they have a different level of voice on the character question, more voice on the character question than they would on the sale itself?
Well, again, this goes to the unique statutory scheme that's in front of this court under 309 and the Communications Act. Any aggrieved person is permitted, and the statute wants that aggrieved person to bring character issues to the Commission's attention. We are certainly aggrieved by the loss of unique investment, by the FCC's decision here to assign the license to an unqualified buyer. We have lost our unique investment as a result of that decision in this unique case, in this circumstance. That's what this case is about. It's not about a business dispute that's bubbled up from the district court. It's about the FCC's obligation to evaluate character qualifications of a buyer. And our case is predicated on a showing that this buyer is not qualified. And therefore, as a result of that FCC decision, we lost our unique investment. Your Honor, I would point out, as I did in the briefing, that the very asset purchase agreement in this case, by which the majority sold the station to the minority contains a provision on specific performance that talks about how the station is a unique asset and the loss is not compensable by money. And that's exactly our position as well, that our loss of our unique investment in the station is not compensable by money, even if we had received the consideration that you asked me about, but which I told you we didn't get.
But we as a court and the FCC as a tribunal is limited in what it can award, especially as Judge Walker was pointing out, where the original LLC may no longer be in business. They exist, I understand, for the unwind purpose. So again, Judge Walker asked, in terms of redressability, you're envisioning an unwind goes from TV 49 back to OTA, back to the LLC. The LLC in its nascent form says, okay, we're going to have a character assessment of OTA, finds out OTA is terrible, ineligible, can't buy the station. And TV 49 says, never mind, we're happy to buy it from the LLC for its market price. What redress does your client envision it's going to obtain, given that that seems to me the most likely scenario?
Again, Your Honor, that's a hypothetical that doesn't exist, may never exist. We don't know, but
it seems like it's the best hypothetical for your client. I want you to tell me the hypothetical that you're imagining that gets robust redress.
The hypothetical I'm referring to is the sale to TV 49 upon getting all the relief.
But I'm saying, what are you imagining? What are you envisioning is the relief that's more satisfactory?
Just the relief I'm seeking, that our unique investment will have been restored. That's all this case.
Restored to the LLC?
Yes.
And then what?
Well, then we'll see what happens. I don't.
What are you envisioning? I mean, you need to be concrete with us, because as Judge Walker asked, if the LLC is there only in its nascent form because it's legally required to be able to participate in an unwind, it's not going to go back into business. And or is that what you're envisioning? I just want to know what you're envisioning.
I'm envisioning that it will, because there's California litigation that's seeking to restore it to business, and that's pending, and the result we don't know. But if you're asking for my best case, yes, the KXT LLC will be restored to business. The cancellation will not hold, and nor will the dissolution, and they'll be back in business operating the station again. That's my best case, and.
That seems highly conjectural. I mean, one of the inquiries we have to make in assessing standing is whether something is likely or speculative. And the notion that a company that long ago sold this asset would not sell it to a ready, willing, and able buyer that does meet a character standard seems conjectural, but you can tell me what I'm missing in so surmising.
Well, the relief that I'm seeking, which is the restoration of the license to KXT LLC, that's what the case is about. That's not conjectural. What you're asking about is conjecture beyond that, which again, as I said, can't be used to defeat me at the back door. It's a front door question about hypothetical injury. We have been injured by the concrete loss of our investment. We're seeking its restoration. That's what the case is about. For this court to then
you've been injured by the loss of your investment because the only claim here is the character claim. You've been injured by the loss of your investment to a buyer of, bad character. And if a buyer of good character purchased, you would have no harm. Because this is a claim only about the FCC's failure to make a character determination. The FCC is not in a position to say, and therefore this asset cannot be sold. It can be sold by the majority shareholders to anybody of good character on your theory.
That's not the relief I'm asking. That's not the relief I'm asking for.
It may be the most relief you're legally entitled to. I'm giving you every benefit of the doubt and saying, terrible character of OTA, disaster, can't hold. Okay, unwind all the way back to the LLC, but nothing about your claim, which is a character claim, prevents the LLC from selling to the next willing buyer of impeccable character.
But with the right, but with the return of the station to KXT, the injury has been redressed. You're then talking about subsequent events, which may, create a new issue, but my injury has been redressed. The asset, the license has been returned to KXT LLC, and that has redressed my injury. As minority owners, we have reclaimed the investment. And so to spin it out beyond that and imagine what might happen in the future is hypothetical, and I don't believe is defeats my redressability showing, because the relief has redressed my injury in this case. That there may be another case as to what happens in the future with another sale, but that's not this case before this court. And so
I suppose the concern here, though, is that this is not the usual type of Article 3 question where we don't know what would happen among these various, I'll call them parties. We do know, because we know OTA sold to TV 49. And while they both took the title at the risk, we know what's happening. So this is not a question of deferring to your allegations about what would happen. We know what would happen. And
I'm sorry, I'm not understanding. We know what would happen when?
We know what happened in this case all the way to the sale to TV 49. And I thought what Judge Walker was trying to focus you on is that those are the facts before this court in terms of, not to put words in his mouth, but one way to assess whether or not your clients have likely been injured. And then Judge Pillard came forward pointing out how minority shareholders are normally taken care of. It's not as though your clients own the station, or it's even your client's company that owns the station, if you win down the road, as I understand it.
My clients, though, had a 42% concrete investment in the station, and they lost that unique investment. It's unique, Your Honor. It's unique investment, a unique asset. And
but the market can value even unique things. It does every day. It ballet tickets, it values works of art, it values, psychotherapists, it values all kinds of unique services and assets, and it valued this one.
And the contract by which it was sold contains a provision, Your Honor, to which we cited that it's a unique asset. A TV station is a unique asset, the loss of which is not compensable by money. That's in the specific performance provision that we cited in the brief. It's a unique asset, the loss of which is not compensable by money.
But is it a loss to your clients, or was it a loss to the LLC? You keep saying that your clients owned 42% of the station, and maybe as a practical way of looking at it, they did. But is it? Tell me why I should not think about it like this. Your clients owned 42% of a company, and that company had an asset. The company could have had 1,000 assets, and the company sold an asset. At the end of the day, at the end of that sale, your clients still owned 42% of the only thing they ever directly owned, the LLC.
Which owned the unique asset. And Your Honor, to your point,
and you keep saying unique asset. Let's imagine that your clients own 42% of a company, and that company had as its assets 1,000 pieces of art. And the company sold one of the pieces of art. And at the end, and then after that, they own 999 pieces of art plus $1 million, because the piece they sold was worth $1 million. Before all that stuff happened, your clients had 42% interest in a company that was valued at, let's say, 1,000,000 times 1,000. And at the end of the sale, your clients owned 42% of a company whose assets still equaled 1,000,000 times 1,000. So I'm not sure how minority shareholders in a company that were minority shareholders before an asset was sold and minority shareholders after the asset was sold have been injured when their stake in the company and the value of the company has not changed.
Because again, this is a case, again, brought under a unique Communications Act scheme in which under 309, aggrieved persons are entitled to bring character qualifications issues to the commission's attention. And that then needs to be reviewed by this court. The idea that actual owners of a company lack standing to challenge the qualifications of a buyer and are not aggrieved persons under the act and have standing under general standing principles, I think
you're leaving out a prepositional phrase. Unique owners of a company that itself owns a station. They still owned 42% of the company. After all of this stuff happened that they didn't like, they still owned 42% of the company, and the company's value was the same as it was before.
And of course, they invested in the company, as the record shows, because they wanted to have a ownership interest in a TV station.
Right, which is a huge disappointment to them, but that's been resolved in the arbitration. Let me ask you, you've pointed to the any aggrieved person, sort of the broad claim available to raise character defects. So the harm that provision guards against is not the shareholders' protection of unique assets, but presumably a public interest in preventing bad apples from holding scarce and important broadcast licenses, right? We don't want companies of poor character, as the law defines that, to own valuable and unique assets like broadcast licenses, right?
I agree with that, Your Honor.
So that is the harm that the claim that your clients have raised is available to redress. Now, there is no ownership by the company that you have persistently identified as such a bad apple. Why is that not full redress of the injury, this particular injury that you've raised? The injury cognizable by the character provision of the Broadcast Act?
Well, because we've, again, I don't want to sound, I know I might sound repetitive, but we've lost the unique investment that they intended to and did secure in a television station, the owner of a television station, and I want to because the focus has been on standing, and I understand the court's concerns are withstanding. There is the alternate showing that we made as to viewership, and I understand the argument the other way, viewership plus what? If we leave aside for a moment the standing, which I believe we have as owners, which in 309 cases is unusual. It's unusual to find owners in 309 cases at all, but we're also viewers and programmers of the station. Ravi Kapur, as the record shows, had the rights to have Dia TV, a channel that he owns and programs on KXT LLC. And the first thing that OTA did upon acquiring the license was throw them out of the station and take them off the air. So, you know, the injury is not limited to the loss of that investment. The injury also goes to the loss of a program channel owned by Ravi Kapur. And again,
but is any of that the object of the character provision of the communications law? It would seem to me that you have a nexus problem and showing that the harms that you are identifying, which may be concrete, that they are caused by, or maybe more vividly, that they could be redressed by the remedy that you're seeking?
I think those showings of viewership and loss of DTV carriage are a classic type of showing in a 309 case. Viewership goes back to, they cite the Rainbow Push cases, with which I know Judge Rogers is familiar. They go back, a little bit in time, but those cases stand for the proposition that viewership plus what? Well, in this case, plus the loss of DTV carriage, which is a programming link to this case. So, my view, injury and concrete injury abounds in this case.
But those cases were not about the character of the sale or purchase party, right? Yeah,
they were. The Rainbow Push were challenges to buyers in the sale of a station because the seller, they had to do with the viewership discrimination. They were discrimination cases for the most part, but they had to do with the character. Character was very much at play in those cases, and the question is, what right does what makes for an aggrieved party under 309? And we have, not only are we owners of a unique asset, but we're viewers that lost the programming channel as a result of the sale to an unqualified buyer. I mean, again, that's ultimately what 309 is designed to allow, aggrieved parties to bring character qualifications to the FCC's attention in a licensing proceeding. And that's exactly what happened here. And we have shown multiple ways, establishes multiple grounds for standing under all three tests: injury, traceability, and redressability.
All right. Why don't we hear from the FCC, and then we'll give you some time.
Thank you, Your Honor.
Good morning. Good morning, Your Honors. May it please the court, I'm Sarah Citron for the FCC. And in our view, although Mr. Corbett has said this is not a business dispute, that's exactly what this case is. In arbitration and state court proceedings, the Kapurs lost their bid to prevent their former business partners from selling the station, the unique asset. They then sought to forestall that sale by bringing before the FCC a series of character complaints against OTA, the purchaser. The commission reasonably found that none of those allegations warranted an evidentiary hearing. And although there are numerous grounds on which this court could affirm that decision on the merits, it lacks jurisdiction to do so because the Kapurs lack standing. And I'll turn, if I may, to the standing issues first.
Do you also think they lack mootness? Or, sorry, do you also think that the case is moot?
Well, your question about mootness, I think encompassed two problems. One was the redressability issue that the LLC has been dissolved. And that's the way we view this case. We haven't pressed the position that the transfer of TV 49 rendered the case moot, or I guess it happened before the case started, so maybe that would be a question of standing. But in any event, we don't dispute that if for some reason the Kapurs were to prevail in this case, which there's no reason they should on the merits, the TV 49 transaction could hypothetically be unwound. But the redressability issue of the dissolved LLC is a real problem for the reasons I think the court, some of the reasons some of you have articulated, which is to say, I think as Judge Pillard recognized, no matter the legal status of the LLC to unwind or pursue litigation causes of action that may have existed before the start of this appeal, at no time in the course of this appeal has the LLC been in a position to operate as a going concern, which it would need to do to function as the licensee of this station. And that remains true today. There was a lawsuit that was filed after the FCC filed its brief in this case and pointed out the dissolution of the LLC. But not only is the result of that litigation speculative, and I think I would agree that the most likely, it doesn't seem likely to succeed, but whatever the likelihood of that suit, what matters for purposes of the standing analysis is, were these injuries redressable at the time this appeal was initiated, or at any time in the course of this case? And because the LLC is not in existence as a going concern, they aren't redressable.
Mr. Trin, I have a, please, Judge Rogers.
Thank you. What about counsel's argument about the nature of Section 309 that, where are you, that necessarily you want minorities, shareholders to be able to appear before the commission when the challenge is based on character. So in other words, in that scenario, why don't we look at the question of standing from his client's perspectives as and Section 309?
Your Honor, in our view, that approach would be contrary both to the shareholder standing doctrine and to this court's decisions concerning audience standing. It seems to suggest something even broader than the idea of automatic audience standing, which this court in the 2003 Rainbow Push case, unequivocally made clear that there is no such thing as that broad automatic audience standing. And with respect to the minority shareholders, before this court, setting aside any issues of administrative standing, this court doesn't allow minority shareholders to vindicate rights that belong to the corporation, here the LLC. And what the Kapurs have said is that they are seeking to vindicate their ownership interest. And there is no distinction between their ownership interest and the LLC's ownership interest. They have only a derivative interest. And in that case, there's no reason that they should be able to stand in the shoes of the corporate entity.
I was surprised to see so little case law on that point, because it seems coherent to say that whatever interest is being asserted as concrete and supportive standing would have to be an interest that minority shareholders themselves are legally, capable of asserting. And the notion that they can't assert an ownership interest, it would seem like there would be dozens of cases on that, but I didn't see a lot of case law on that. It seemed actually quite thin. We have this Ninth Circuit case. And so what's up with that?
I'll acknowledge Judge Pillard. I had something of that reaction myself. And it may have to do with just the different factual, the ways that these cases present themselves factually. They're not always, maybe the volume of them is not sufficient, at least in the FCC context, to produce a line of cases that are directly analogous. But there are a number of unpublished decisions in this court, the K versus FCC, Bob Law versus FCC, that I think are consistent with this, this more abstract principle of not allowing third party standing, which I think is, really clear, if not factually on all fours. The franchise tax case, the Supreme Court case, makes clear that a minority shareholder in the Kapur's position should not be able to pursue these, to rest on the idea that their concrete injury is an ownership interest that actually belong to the company. And I think one of you was pointing out too, there is a bit of a causation issue where Judge Walker, your point was, and I think it's correct, that at the start of this case, or at the start of the FCC proceeding, the Kapurs had a 42% ownership interest in the LLC. And at the end of the FCC's proceeding, they did as well. The sale was really a function, a contractual, it was a function of their minority interest in the LLC. And it's not something that arose from the FCC's decisions. But if the court is struggling with the abstract concepts of shareholder standing or audience standing and what is enough of a nexus, and I think, by the way, that Mr. Corbett hasn't established a nexus between the Kapur's asserted role, and it's really Ravi who has attested that he's a viewer of the station, but there's no connection between that interest, that viewership interest, that public interest, and the private interest that Mr. Kapur has asserted, and again, not attested to, but asserted in as Daya TV's founder and as someone who is interested in the programming of Daya TV. But all of those difficulties are swept aside by the redressability problem, which is that, whatever, as Judge Pillard put it, if the Kapurs were to get everything they wanted here, and if OTA were a bad actor, and the FCC had acted irrationally, there's still no way to restore this station to KAXT LLC as licensee.
Is there a simpler way to look at that? I mean, it seems even maybe more than the character provision and the broad availability of a character claim is there to remedy, to think about ownership interests, that I mean, the harm is there because the Congress thought that it would be a public problem for bad apples to own broadcast licenses. And it seems in a way neither here nor there whether someone who is claiming a transfer to an owner of ineligible character has any other concrete interest, or help us out with that. Like, in a way, it just feels like it relates to a different claim to worry about the ownership interest, but maybe that's too cut and dried.
My understanding is that, and the commission has an informal objection vehicle also, which is partly what was at issue in this case, where I think parties that might not be able to, that may not have a concrete injury could object and bring issues to the commission's attention. But I don't, again, I want to be clear not to confuse here the requirements of administrative standing and judicial standing. I think it's very clear under Section 402 that a party aggrieved is someone who meets the elements, the three standard elements of Article 3 standing, and the Kapurs just can't proceed in this case unless they can satisfy all three of those, which they haven't. I see my time is up. If I could briefly make just a couple of general points about the merits, because I think we easily win there. I'd like to emphasize that this isn't a case, as the Kapurs have represented, where the commission ignored their allegations against OTA. The commission looked at these, took them seriously, addressed them in a number of opinions, as Judge Walker alluded. And so that's just not this case. And in addition, the issue here is really, did the commission reasonably determine, or was it irrational in deciding that no evidentiary hearing was required on any of these allegations? And that's a question of internal FCC process of a kind to which this court gives the commission considerable deference. And at bottom, I would just say that on none of the 5 issues have the Kapurs come close to showing that the commission's reasons, which it explained, were arbitrary and capricious.
I think that the concern is what is the narrowest ground on which standing might be available to even reach the merits? And it's a little bit it's a little bit tricky. I think it's probably lack of redressability rather than lack of harm.
Well, of course, we maintain that there's no harm either, but I don't disagree that there's clearly no possibility of redress, and that might be the most straightforward path for the court.
Ms. Citron, another straightforward path is that every petitioner has a duty to show that we have jurisdiction. That means they have a duty to show standing. In the petitioner's blue brief, they did not show that they had standing. They didn't even try. Instead, they put it not in their brief, but they put it in an addendum, which allowed them to exceed the page limit. Now, they cite a DC Circuit checklist on the DC Circuit's webpage, which says that they can do that. Of course, a webpage cannot override a circuit rule. Do you think that because the webpage seems to say that they can do what they did, that we should allow them to do what they did, or do you think we should stick with the actual rule, in which case we wouldn't even read their standing argument, and in which case they haven't showed standing?
Well, Your Honor, that is our view, that it was an improper use of the addendum. It took them over the word limit. So certainly if that's the path the court chooses, we think that's a viable.
What's your best argument for why it's fair for us to do that and not unfair, considering, we do have this webpage that says maybe they can do it?
Well, I think by their own admission, they use this vehicle because they otherwise wouldn't have had enough words to make their showing. I believe we pointed to that in the footnote of our brief addressing.
You did. There are dueling footnotes on it, and I'm good. I don't have any more questions along this. I just wanted to hear your thoughts on the fairness question.
Certainly. If there are no further questions, I respectfully ask that the court dismiss the appeals or in the alternative deny them. Thank you.
Thank you. All right, counsel for petitioners.
Thank you, Your Honor. A couple of points on redressability, which was addressed at the well, first, let me address Judge Walker's point about the strict application of the rule. Our brief was under the word count, and we simply, for the court's convenience, put the standing showing, rather than bifurcate it, as that rule would suggest, strictly bifurcate it, we simply put it all in one place for the court's convenience. I think it would be an incredibly harsh result to read that rule as including this case because of the form in which we presented our standing showing. I would point out that even in the text of the brief, in case 1048, we do address to the standing argument briefly as well there. It's not all the entire standing showing, and the three prongs are certainly shown in the brief in the 1048. So we were following what we understood to be court guidance on that, and it was not a device to exceed the word limit. Even the government concedes that you could bifurcate it, and we could simply bifurcate if the court felt that was important to for some formal reason. I want to realize that there was no finding of a standing problem below. The commission never challenged our standing. OTA never challenged our standing. I believe because it was self-evident. One of the things I didn't point out earlier was that, again, these are particularized cases involving the Communications Act and FCC processes. The Kapurs, as owners of an LLC, were actual parties to the FCC application itself, which is the subject of this appeal. They're parties to the application, and that's because the FCC views LLC members, regardless of their percentage, as having enough influence as to matter for FCC purposes. So I believe that there was no challenge to our standing from the beginning because it was self-evident that as owners of the facility, owners of the licensee of the facility, that our standing was self-evident. So it wasn't challenged. Again, it's as a party to the application, the commission and this court should actually welcome parties bringing character issues to the fore and bringing them to this court for review to make sure that the FCC is upholding its obligations as spectrum steward. I strongly disagree with opposing counsel's representation. The commission did everything right here. In fact, under motor vehicles, the 3 tests, they did practically nothing right in our view, as the brief shows. Their decisions run counter to the evidence in front of the agency. They're entirely fail to consider important aspects of the problems, and they offered rationales that are so implausible as not to survive judicial review. So we differ strongly on that. I understand the
What's the time period, Mr. Corbett?
Yeah.
The perspective from which we evaluate your client's standing. Typically, when we get a case from an agency, we look at the standing, I believe, at the time they come to court, because the standing only applies to the Article 3 tribunal. In this situation, is that the right temporal framework, or is it something else? And if so, why? In other words, we assess standing as of a particular time.
I don't think so. I don't, based on, for example, the Stoles case, other cases, justiciability and issues can arise later than the filing of a brief. This court always needs to satisfy itself of standing. So I don't believe that there's a hard and fast, bright line at the time of establishing standing. You need to have standing the time you file, and I need to have standing today, which I believe I've shown. I did want to add on redressability that, again, the issue before this court is whether the injury in this case is redressable in this case, not in some other case down the road, not in the future, not based on what might happen, but what will happen in this case. And there's no contesting, even by a government counsel, that the unwinds could be ordered and the license restored to KXT LLC. That's what this case is about. And I understand you have speculations about another case down the road about what might happen in the future there, but that's a hypothetical at the back door that can't defeat my standing when I have shown a concrete injury at the front door, namely the loss of our unique investment. So I think it would set, and to your point about the lack of minority shareholder cases, I think that's highly relevant as well. They cited Iacopi, but of course, Iacopi expressly declined to find that a minority shareholder lacks standing based on court liberalization of standing principles. And I think it sends, any holding to that effect would simply shut the doors of the court for reviewing agency action. I don't see why the court would want to do that in this case. This court should be sitting in review of FCC's failures as spectrum steward. That's what the Communications Act envisions. That's what 309's express language is all about. Aggrieved persons. We're aggrieved persons in multiple ways. As I said, injury abounds. We have multiple injuries we've brought to this court's attention.
All right. We will take the case under advisement. Thank you.
Thank you, Your Honor.
Honorable Court is now adjourned until Thursday, January 7th at 9:30 a.m.